This presentation is going to focus on the basics of dental insurance contracts. First up, you do have a choice, and this is something that new dentists and old dentists alike, I don't think take into consideration enough. And at the end of the presentation, I'm going to ask the question, is participation worth it? Once we've gone through all of the benefits and the burdens of participation, and some questions about things that can and do come up routinely when you do participate with a dental insurer or a dental plan. It's whether you should participate or not is an analysis that at least on an annual basis, everybody ought to be asking themselves. So, as I said, we'll talk about the benefits and the burdens of participation, but what happens if you do not participate? You are able to bill and collect whatever fee you want to charge directly from the patient. You may, as a courtesy really, file a claim with an insurer or a dental plan on behalf of the patient if you wish to, and that will enable the patient to be able to get the dental benefit that they're entitled to from the plan or the insurer, and you have to decide whether you're going to collect your fee up front from the patient or wait until they get the money from their insurer or their dental plan later on. Obviously, that has risks associated with it, collection risk. Will your bill be paid if you don't collect it up front? And that is something that you have to weigh in the balance. And again, when we get to the end and we're talking about assessing whether you should participate or not, we'll come back to this and talk about it a little further. If you participate or you join a network, however it is described, merely contracting would be the other way that it's typically talked about. All that means is that you have signed a contract with a dental insurer or a dental plan and have agreed to the contractual terms and conditions. Now, first of all, the benefits of participation. And these benefits, I'll say up front, these are what they are supposed to be. Whether they actually materialize and to what extent they actually materialize is going to vary on a case-by-case basis, dependent on a number of factors. But these are typically the reasons why dentists enter into participation agreements with insurers or dental plans. First and foremost is increased patient flow. What the insurer or the dental plan ought to be obligated to do in the contract is to promote that you are in the network and available to their insureds and their enrollees and their plans in the directories that they put out, announcements that they make, advertisements, when they're advertising generally in the area where your practice is located. All of these things ought to be done, and the insurer or the dental plan ought to be contractually committed to do so in the participation agreement. Other reasonable actions to steer patients that are enrolled in their plans or plans that they administer to your practice. The other thing that ought to be readily provided and ought to be spelled out in the contract is eligibility identification. And anytime there is a question about whether a benefit, a service, is covered or not covered, and to what extent it's going to be covered. There ought to be a contractual obligation on behalf of the plan or the insurer to get you that information, and a reasonable means of asking for the information and getting a quick response. So that if a patient is sitting in the chair and needs a crown or needs a filling, and there's a question about whether there's going to be coverage for it or not, so you can get an answer very quickly and even on the spot if need be. Next, timely payment in bulk. And what I mean by that is, as you're performing services throughout the day and on a day-to-day basis, you're going to be submitting claims electronically, and you ought to be paid for those claims in bulk, meaning you'll get a single check and it'll cover multiple claims. And the contract ought to spell out the terms that you're going to be paid by. Michigan has a timely payment statute, and in any contract you have with an insurer or a dental plan, this is the baseline. The terms ought to be at least this favorable, if not better. And under this act, if claims, clean claims where you provide all the requested information, and there aren't any questions or any problems with the claim, need to be paid within 45 days. If they're not paid within 45 days, interest begins to accrue at a rate of 12% per annum. At one time, Delta Dental was exempt from the requirements of this act. That's no longer the case. Delta Dental is no longer exempt. So that's the baseline. 45 days, frankly, is a long time to wait to be paid when you're filing claims electronically. And again, if there are no problems with the claim, all the information is submitted and it's submitted properly, really on a weekly basis, or within 15 days or so, you ought to be paid. Especially if the payments are going to be coming into you electronically and not via the mail and a check. That's typically the way that it works these days. The contract ought to provide, and you have the right to know the fees in advance. A number of times I'm told by clients that they've never seen a fee schedule, and they don't know what they're going to be paid until they sign a contract, they submit a claim, and the payments start coming in. When they see the checks, the payment amounts, that is the first time that many people know what it is that they're going to be paid. I don't know how anyone does business on that basis. In healthcare, that is the only way that it works that way, where you're selling your services or a product, and you don't know what you're selling it for until you actually make the sale and you get paid. Healthcare is the only business where that happens. You ought to insist up front before you sign the agreement to know what the fee schedule is, and even if the insurer or the dental plan doesn't want to give you a copy of the fee schedule, they ought to make it available to you on some basis. So you give you a secure site that you can go to and review it, or by some other means let you know what it is you're going to be paid ahead of time. Balance billing rights. We're going to talk a lot about this in a few slides coming up, but balance billing means that if your normal fee for a crown, let's say, is $750, and the fee that you've agreed to accept from the insurer or the payer, let's say, is $650, under what circumstances can you bill for the balance, that extra $100? That ought to be spelled out in the contract so that you know up front. A little bit later on, we're going to talk about a couple of examples where this becomes very important. And again, you shouldn't have to wait until these situations arise to find out what the answer is. The contract ought to be very clear about when you're able to balance bill and when you're not up front. So those are the benefits of participating. Now we're going to talk about the burdens of participation. And there's going to be more slides on burdens than there are on benefits. And I want to just say up front that not all of these some of these burdens I'm going to talk about are potential burdens. These things don't come up with everybody on a routine basis, but they are things that are typically included in participation agreements and can be problematic, and that's why I'm bringing them up. Now, many of these burdens are potential burdens; they're not actual burdens. First, the fees, even though you know what they are up front, are capable typically of being changed unilaterally by the insurer or the dental plan, sometimes with notice, sometimes without notice. You got to read the contract and know under what circumstances the insurer or the dental plan can increase or decrease the fees that you are being paid. You ought to insist that if the insurer or the dental plan has the right unilaterally to change the fees, and that's typically the case, that you have the right to terminate the participation agreement if the fees are reduced to a point that you no longer want to do business with that insurer or that dental plan. All participation agreements have a termination right on your behalf. There's usually a with cause and a without cause termination right. The question is, do you, for example, have to give 90 days notice if you're terminating without cause? If the fees are dramatically reduced, should you have to be stuck for that 90-day period working for unfavorable fees? And my advice is that no, you shouldn't. And if fees are going to be unilaterally reduced, that ought to give you the right to terminate immediately if the reductions are not to your liking. Second, the prohibition on collecting directly from patients other than co-pays or deductibles. This is the balance billing, or the prohibition on balance billing that I talked about on the previous slide. All participation agreements, in most cases, are going to take away from you the right to balance bill. You're going to only be able to collect co-pays and deductibles from the patient, and then you're going to have to accept the fee that the insurer or the dental plan agrees to pay you, and that is going to be all you're going to receive when you render services to an insured or an enrollee. Lastly here, and this hasn't come up lately, but this used to be a big deal. Not everyone is paid the same fee. Some insurers or dental plans have different fees that they pay, usually based on geographic differences. And what I mean by that is they will determine that the cost of doing business in location A is significantly higher, the rent that has to be paid and other things, than it is in location B. And they will vary the fees that they pay accordingly. All the more reason to insist on being given a copy of the fee schedule in advance. Don't rely on what your friends, your classmates tell you about what they're being paid, especially if they're working on the other side of the state, or if they're working in a big city and you're working in a rural area. The fees may be different based on cost of doing business or the perceived cost of doing business differences by the dental insurer or the dental plan. We've also seen in recent years where the date the contract was signed might make a difference in the fees that you're being paid. If you joined a network, excuse me, if you joined a network 5 years ago, you may be paid at a higher rate than people joining that same network today are being paid. I haven't seen a lot of that, but it definitely has happened in recent years. So again, all the more reason to insist on seeing the fee schedule so that you know exactly what you're going to be paid. Don't rely on what you hear from others or assume that it's going to be the same for everybody, because it may very well not be. Next, many participation agreements contain what's called a most favored nation provision. And what this means is that, say you have 5 different participation agreements you've entered into with different dental plans and different insurers. And the fee schedules are all different, right? So you're getting less from some insurers and dental plans than you're getting from others. A most favored nation provision says that I'm going to pay you X for procedure A, unless you are performing procedure A and getting paid less by some other dental plan or insurer. If that's the case, I'm only going to pay you the lowest fee that you have agreed to accept from all other insurers and dental plans. Many participation agreements contain such a provision. Fortunately for dentists, in 2006, these most favored nation provisions were all but outlawed. There is an exception. If the dental plan or the insurer gets approval from the state to enforce their most favored nation provision, then they're free to enforce it. I'm not aware of any Michigan dental plan or insurer that has gotten this approval. So I think it's safe to assume, even if the participation agreement still contains a most favored nation provision, that it will not be enforceable against you, and you can disregard it. Other burdens, focused review, and other forms of prior authorization. Unless the participation agreement says something different, typically the way it works is it's sort of the honor system. You, the dentist, perform a service on an insured or an enrollee in a dental plan. You file a claim form with that insurer or the dental plan, and you tell them that, on this date, this patient was in your office. This is the procedure that was performed, and that's it. You just submit a claim form providing that information and all the other requested information, and then the claim is paid. There is no requirement typically that you submit copies of x-rays, for example, or copies of treatment notes, or that you provide other information in order to get paid. In the ordinary course, all you're submitting is the claim form, which is going to contain several bits of information But the records, the x-rays, other things, you typically do not have to provide to get paid. Unless the insurer or the dental plan puts you on what's typically referred to as focused review, or tells you that in order for you to get paid at all or to get paid for certain procedures, you have to provide other information first. And this usually happens when the dental plan or the insurer, based on all of the claim data that you're submitting, that you're doing things that other providers in your area, in your specialty, are not doing. It usually happens as a result of a determination that you are an outlier. You are doing more root scaling and planing than other dentists. You're doing more crowns than other dentists, and things like that. And before the insurer or the dental plan will continue to pay for those things, they want to see more information and want to make sure that you're practicing within the standard of care and that these procedures are really appropriate under the circumstances. What you want to see in your participation agreement is when the insurer can do this. And do certain things, objective, are there any objective criteria that have to be present before the insurer or the plan can put you on focused review? What are the factors? How long is it going to last? What types of information are going to be submitted? Do you have the right to appeal to someone within the insurer or the dental plan when you're placed on focused review? And again, what effect does being put on a focused review or some other type of prior authorization program have on your ability to terminate the agreement? And again, what I mean by that is, if under normal circumstances, you have to give 90 days notice to terminate without cause, if you're put on focused review, shouldn't you be able to terminate sooner than that? Or are you stuck for 90 days submitting all of the extra information if you don't choose to do so, or if you think it's just too much of a burden for you and your practice? These are all things that should be spelled out in a participation agreement. Post-payment audits. All participation agreements are going to give the insurer or the dental plan the right to conduct post-payment audits. And what this means is that they may want to look back over all of the claims that they have paid over the last year or 2 years, let's say, and make a determination whether or not those claims should have been paid or paid at the rate that they were actually paid. Lots of questions here and things that should be spelled out in a participation agreement. Many of these are oftentimes not spelled out in participation agreements, and it causes a lot of problems when again, you don't find out what the terms are until you've already signed and you find yourself with a letter saying that they want to audit all your claims going back. So the first is, how far back can an insurer or a dental plan go back and audit? What I always argue is that if you only have 1 year to submit a claim, let's say, the dental plan or insurer should only be able to go back 1 year in order to audit claims. The time period you have for making a claim and the time period going backward to audit claims really ought to be the same. Now, having said that, it hardly ever is. If the contract does not specify how long the insurer or the dental plan can go back and audit. The breach of contract statute of limitations is what usually applies, and that is 6 years. And I've seen many participation agreements where there is no limit on how far the insurer or the dental plan can look back, and they can and do often look back as long as 6 years when auditing. So it's very important that you seek to get a shorter period of time spelled out in the participation agreement. Once you have gone through the audit, and let's say the insurer, the dental plan, has determined that it paid claims that it should not have paid for whatever reason. Say they go back, and now that they've seen the records and seen the x-rays, they've made a determination that the services that were rendered were not appropriate. They shouldn't have been rendered. Or they were appropriate, but they were provided below the standard of care. Or for some other reason, they shouldn't have to pay for those services. What are your rights to appeal those determinations? That's number one. Number two, who do you appeal those determinations to? Is it somebody else but an employee of the insurer or the dental plan? Or does it work like an arbitration proceeding where you and the insurer, the dental plan, will pick a third party that will review all of the information and make a determination whether it was valid that the amounts have to be paid back. Once those appeal rights, if there are any, have been exhausted, what right does the insurer or the dental plan then have to offset or otherwise collect the money that they're now claiming is due? What often happens is if you continue to participate with that insurer or dental plan and they have determined that there's an amount that they're going to recoup, they will start offsetting what they claim they are owed against amounts that they owe you currently for services that you are providing to their insureds or enrollees, which in essence means you are working for free for them until you pay back what they claim it is you're owed. The contract ought to clearly spell out to what extent the insurer or the dental plan can do that. Next, again, I keep coming back to this, but it's very important because sometimes this is the only remedy that you have. What effect does this have on your right to terminate? Again, if you're required to give a 90 days notice to terminate without cause, should the requirement of that 90-day notice go away in a situation where there's a dispute about what you ought to have to repay the insurer or the dental plan? Or are you going to be forced for 90 days or whatever the length of the notice period is to either work for free or simply stop treating patients that are insured or enrolled in that payer's dental plan? These are never good decisions that you have to make, but it's really the spot you're in when this happens, and terminating your participation status may be the only way to avoid recoupment and having to work for free. Last thing I'll point out here for those of you that are employers, you ought to consider in your employment agreements for employees that also participate with dental insurers or dental plans, that if you bill in error and somehow that dentist, because their name is on all of the claim forms that you have submitted on their behalf, if they incur expenses or have to pay something back to a dental insurer or a dental plan, that you, the employer, indemnify them so long as they completed all of the records properly and provided all of the correct information so that the person that did the billing, that's completed and submitted the claim form, had all of the right information, and just didn't do it properly, or worse, did something improperly to cause payment errors. Amendment and termination rights. This is something that, again, is overlooked, especially the amendment section. Nobody seems to worry about this until the insurer or the dental plan unilaterally amends the agreement in a way that isn't favorable to the dentist. Then and only then do people look to the amendment provision, which is usually at the very back, buried in the miscellaneous section, to find out that the insurer or the dental plan has a unilateral right to amend the agreement at any time for any reason. And usually even without notice. Again, if that's the case, it would be reasonable for you, the dentist, to have the right to terminate the agreement once you get notice of the amendment, if that amendment is not to your liking. This is rarely the case, however, and I think the reason is that dentists, when they're entering into these agreements, don't pay attention to those miscellaneous clauses, including the amendment provision at the end of the participation agreement, and think about the spot they're going to be in if there's a unilateral amendment that isn't to their liking. You may be stuck living with it for the 90-day notice period, and it's not a position you want to be in. Termination itself, we've talked a lot about the dentist's right to terminate and how that right ought to be reasonably affected based on what the insurer or the dental plan does to the dentist. But what about the insurer or the dental plan's right to terminate the agreement? It does go both ways. What notice do you have to get ahead of time? What is the difference, or what are the consequences, I should say, of a with and a without cause termination by the insurer or the dental plan? Are there going to be restrictions on your ability to communicate with patients, the patients that you have and you've been treating that are insured or enrolled in the insurance products or that dental plan? In the best of all worlds, you're going to want to send a communication yourself to all of your patients and let them know how they can continue coming to see you and what the payment arrangement is going to be now that you're no longer participating with that insurer or dental plan. You want to take advantage of whatever opportunity you have to retain that business, despite the fact that for whatever reason the insurer or dental plan has terminated your participation. Now, that's it for the benefits and the burdens of participation agreements. And now I want to talk about some very common scenarios that come up that you ought to think about ahead of time. The first is, which patients does the agreement apply to? Obviously, those patients that are insured by or enrolled in plans of the other party to the contract, the insurer or the dental plan, the terms and conditions of the participation agreement are going to apply to them. That's the easiest case. Number two, and less obvious, is those insured by or enrolled in plans of others, somebody who is not a party to your participation agreement. And the most common way that this happens is when you sign a participation agreement with Delta Dental, for example. Delta Dental not only has insurance products and dental plans of its own, but it administers plans of others. The state of Michigan, for example, the auto companies, and other large employers, and collective groups of employers. And none of those other parties do you have a contract with. But your contract will apply to those patients because the Delta Dental participation agreement, and this is typical of participation agreements, says that not only does it apply to patients that we insure or that are enrolled in our dental plans, if we administer an insurance product or a dental plan of somebody else, those insureds and enrollees are subject to this contract as well. Number three, all locations or only some locations. Many dentists will work in more than one office, spend 2 days a week in one office and 3 days a week in another office. When you participate with an insurer or a dental plan, are you participating when you treat patients in both locations or only one of those locations? This is something that's got to be clearly spelled out in the participation agreement. It's the only way you're going to know for sure, and you're going to want to know this up front before you start treating patients. Don't assume that you can vary your participation by location. That may be the case or it may not be the case. The contract will determine that, and you need to know that up front. Lastly, for those of you that have multiple offices, or even if you only have one office and you employ a number of dentists, some of those dentists may participate, some may not. But for those that do participate and work in two different offices, which patients does it apply to when those dentists are working in multiple locations? It's going to vary contract by contract, and this is something you need to make sure you map out ahead of time. Next, now this says at the top, which patients does the agreement, it should say which services does the agreement apply to, because there are going to be times when the same service, the contract applies, and other times it doesn't. So first, the service is necessary and it's deemed appropriate by the dental plan or the insurer, but benefits are exhausted. For example, the dental plan provides that there is a dollar cap on the amount that the plan will pay for certain services. Orthodontic services, for example, is a fairly typical example. It may also be a limitation that applies to a particular service. You only get 1 crown per contract year. So the question is, what happens when the patient has reached one of those limits? Say it's a one crown per contract year limit, and the patient has broken their second tooth within that year, and they're now in the office and they need that second crown. There isn't any coverage, right? Because the limitation has been reached. So does that mean that the contract does not apply and you are able to charge the patient, and the patient has to pay whatever fee your normal fee is, not the discounted rate provided by the contract? Most contracts will provide that if the service is a covered service, that is, it's a crown. Normally there's a benefit for the crown. Even if the limitation has been reached and the patient is going to be paying you out of pocket for that service, the contract still applies, which means you can only charge the patient the fee schedule amount and collect only a copay and deductible from the patient, in addition to that discounted fee. You can't charge your normal and customary fee. Second example is where the insurer or the dental plan disagrees with you that the service you're recommending to the patient is appropriate. And you should realize here that there are many times a difference between the standard for payment and the standard of dental practice. And because what I'm talking about here is where the insurer or the dental plan disagrees with the dentist about whether or not that tooth really needs a crown, or root scaling and planing is appropriate and necessary. When there is a disagreement and the insurer or the dental plan is disallowing the service, they're saying that it should not be provided and they will not pay for it, then what is the dentist to do? First of all, you need to document and educate your patient on why it is you're recommending something that their dental plan or insurer is saying that they shouldn't have, and make sure you note that in the record. And there really are no good choices here when this situation occurs. I mean, really, all you can do is refer to a non-participating dentist, which obviously nobody wants to do, or you can provide the service for free, again, which nobody wants to do. But even if you do decide to give the patient what you think they ought to have, you should file a claim with the insurer, because typically the participation agreement is going to say all services provided to insurers or enrollees, you have to file a claim. You have to put the insurer, the dental plan, on notice that the service was provided, even in situations where the dental plan or the insurer is not paying for it. Now, there's one other option here, and this is never contained in a participation agreement, but is contained in HIPAA. HIPAA contains a provision stating that when a patient notifies the dentist that they are going to be paying cash in full for a service, the patient can direct the dentist to not file a claim with the insurer or the dental plan. And here is the problem with this. If the dental plan or the insurer disallows a service and the patient in response tells the dentist, I want the service that you're recommending, I will pay you in full, in cash for it, and I'm directing you not to file a claim with my dental insurer or dental plan, you go ahead, provide the service, bill and collect from the patient, not file a claim with the dental plan or the insurer, and everybody's happy, right? Unless someday there's a post-payment on it, and that patient's records are some of the records that dental plan or insurer wants to see as part of the audit. And they see, when they review the records, that you provided the service even though it was disallowed by the dental plan or the insurer. Then what? Is it a breach of contract because you did not file a claim when the agreement, the participation agreement, required you to file a claim? Can it be a breach of contract when you're following federal law? And will that be acceptable to the dental plan or the insurer? I don't have an answer to this question. To my knowledge, this scenario has never been litigated. There are no court rulings on it, so I can't tell you for sure what the result of that would be. But this HIPAA provision may come in handy if there is a service that you think a patient ought to have, that the patient is ready, willing, and able to pay you for out of pocket. This may be your only alternative. Lastly, here, and I said I would come back to this, is participation worth it? Now that you know that when you sign a participation agreement, you know, the good news is you're going to get timely payment in bulk. Hopefully it's going to result in you having access to patients and your practice being marketed in ways that it wasn't before, and those are all very good things. Are those things worth it, though, when you could be put on focused review, and instead of submitting a claim for payment being a sort of a perfunctory process where you're just filling out a form on the computer and hitting send over and over again, and you're getting, the money is just showing up routinely in the mail, does it turn into having to, you know, copy x-rays and copying treatment notes and getting on the phone and having a conversation with somebody, a dentist that works for the insurer or the dental plan that's challenging your diagnosis and treatment plans? Is it worth taking the risk that, you know, any day in the mail, you could get a letter saying that we want to look back at 6 years worth of claims that we have paid? Is it worth taking the risk that the result of that audit is that you have to pay back the bulk of everything that you have been paid over the last 6 years? And again, how do you go about doing that? Is it really worth it? And this is something that ought to be reviewed at least on an annual basis. And you ought to make a conscious decision that it is worth it if you're going to continue. The worst thing that happens if you cease participation is you need to bill and collect from your patients. If you make available to them an arrangement through Care Credit, for example, or they otherwise put a credit card on file so that you charge them and get paid via their credit card at the time the service is rendered, and then you file the claim on their behalf, and when the benefit comes in to them, they then, you know, pay their credit card back. There are ways to manage the cash flow that may be palatable to your patients. And again, there's no right or wrong answer here, but this is the analysis that you need to go through at least on an annual basis to determine whether the risks and the burdens of participating are really worth it for you and your practice. We've got a few minutes left, and I'll take any questions that there are, Shauna, if there are any. I don't see the chat window.
Yes, we do have a couple questions, Dan. The first is the provider notified specifically that they are under focused review, or is this just sent in the form of a prior authorization without other notice?
There's got to be notice. When I say focused review or other prior authorization, what I'm referring to is the dental plan or the insurer sends you a notice and says that for crown procedures, let's say, before we are going to pay for crown procedures going forward, you need to submit x-rays and treatment notes so that we can make a determination that the tooth really needs a crown. So you would know that it's going on because you're being asked for the information, and you're going to have to supply it before you're able to get paid.
Next question. Can you negotiate fees with any insurances?
It depends on the practice. In most cases, no, the fee schedule is the fee schedule, and you will be told that it is what it is, and it's what everybody else in your geographic area is getting. And if they pay you more, then they got to pay everybody else more, all of these types of things. Having said that, I do know of cases where, very large practices or different practices that are owned by the same dentist or group of dentists that have just kind of the clout, the patient base in a certain area where the insurer, the dental plan really needs them to be in the network. Where they've been able to negotiate and are paid higher fees than other dentists in that area are paid that don't quite have that market power, if you will, or that clout. Again, don't assume that everybody's being paid the same amount, because they may not be.
How long is a typical contract length?
This really doesn't matter. And I say that because the term of a participation agreement is typically, it begins on the date that you sign it, and it continues until somebody terminates it, right? That could be 1 year, that could be 5 years. There are many Michigan dentists that have participated with Delta Dental for 30 years. And it's still ongoing. So really, the length of the notice period for a without cause termination, both by you and by the insurer, the dental plan, that's really the length of time you ought to focus on and make sure you're aware of, not the term of the agreement, because the term is really open-ended.